Order. Point of order. Victoria Collins.
Point of order. Thank you, Mr. Turner. I'd like to make a point of order about new clause 30, which I know wasn't selected for debate. Many will be familiar with the story of the constituent of the Honourable Member for Cheltenham, Ellen Room, who lost her 14-year-old son Jules in 2022. Jules was a happy boy. He died in tragic circumstances. In her search for answers about the circumstances leading up to Jules' death, Ellen has come against outdated laws and social media giants taking an intransigent approach to sharing data that should naturally be hers as a bereaved parent. We're talking about things that in the past she would have been able to find out by looking through her child's bedroom, things that might have been in wardrobes, stored under bed or in school notes. These days, those bits of data could be on multiple social media accounts with parental access is disallowed. This is the subject of new clause 30, which was submitted by the Honourable Member for Cheltenham, Ellen's Member of Parliament. The change to law would be known as Jules' law in his memory. This would give parents access rights to their deceased child's data automatically, with certain safeguards, of course, to respect third parties, so other grieving parents will never face the challenges and the huge legal costs that Ellen has had to endure. I know this clause has not been chosen for discussion, but I'd welcome a meeting with the Minister, with my colleague, to discuss this issue further. Thank you.
Yes, further to that point of order, the reason it's not been chosen, it's not because anybody's wanted to be sort of ruled inadmissible or anything. It's simply because we're cracking through the bill at such a speed that I think it might have been anticipated we'd still be sitting on Thursday, but it seems likely that we'll be finishing today, and therefore it can't be reached today because of the late tabling of the, motion, of the amendment. I know Ellen is in the room, and I'm very happy to facilitate a meeting with her, which I think is still outstanding with the department, actually. So we will make sure that that happens before we get to report stage, and I'm very happy whether the member for Cheltenham or other honourable members want to be present at that meeting as well. I'll make sure that that happens. This is not any attempt at a slight of any kind. It's just an accident of fortune in terms of the tabling of amendments.
Very grateful to the Minister and indeed to the Honourable Lady for raising the point of order. We now come to the Amendment 21 proposed to clause 117, with which it will be convenient to also consider amendments to new clauses 10, 11 and 16. I call Steph Aquoran to move Amendment 21.
Thank you, Mr Turner, and I beg to move Amendment 21. I rise indeed to speak to the 4 amendments and new clauses which the Chair has referenced in my name that are grouped here. That is new clause 10, which requires the government to bring forward a data, vision and strategy within 6 months of the passing of the bill. This coupled with Amendment 21, which would add a new function to the Information Commission to allow it to support the government in the drafting and delivery of the data, vision and strategy. New clause 11 seeks to ensure that all departmental boards and NHS bodies have senior staff with data and technology expertise at the highest level. And finally, new clause 16, which would require the government to publish annual reviews of the use of data within the delivery of public services and ensure they would include updates on the progression of a number of key goals. I want to turn first to new clause 10. In previous speeches in the House, I've tried my best to emphasise the transformative power of data in our era. It can be seen as similar to the discovery of fire or gold or oil, such as its value and ability to totally reshape how we approach the world. But I think the most accurate comparison is how similar it is to Edison's harnessing of the power of electricity. I invite you, Mr Turner, and the committee to imagine that government is like a 19th century factory. Prior to electricity generation, a factory had to be organised around a single power source, usually a steam engine, with every machine that needed power connecting directly to the central drive shaft above. Components could be made, yes, but then had to be transported elsewhere to be assembled, usually by hand. By harnessing electricity, it was possible to pipe power anywhere on the factory floor. This meant the machines could be placed wherever they were needed, becoming more precise, more efficient and more specialised, and it led to mass manufacturing with the product as the central organising principle of industry. So what does this have to do with modern government? Well, the data revolution that's been underway, the data revolution rather, that's been underway since the 1990s means that the structures and organisation of government can themselves be transformed in the same way that industry was in the 1890s. We can use data to shift away from archaic practices and government functions, some of which do occasionally feel like they might still run on steam power, and shift towards public services that make the citizen experience their central organising principle. With the true free flow of data through government, we can bring services to people, make them easier and more efficient to use, and radically improve how people interact with government. But in order to do any of this, the government needs to develop key principles to enable them to seize this opportunity. Creating a data vision will show what the future could be for the use of data across government, setting out where we want to get to, how we want services to run, and what the ideal citizen experience will be. From this vision, which I hope would be ambitious and wide-ranging, the government could then design a strategy to deliver on it, outlining how they're going to seize the transformative power of data to improve the workings of the state and ultimately deliver a better experience for all of our constituents when they come into contact with government or the state. A national data strategy was, in fact, published under the last government. It was consulted on during 2019 and published in 2020. It's clear that the world is a very different place to 2019. The pandemic made government rapidly reevaluate and improve its relationship with available data to handle a national emergency. And there are lessons to be learned from that. It also forced a change in many people's habits and expectations. We're prepared to act far more digitally now, but also expect that businesses and corporations and government will be more adept in the experiences they provide for us. While much of what was in the last data strategy was heading in the right track, I'm sure that with a new government and a new world, the government would want to make their own mark and fully harness the data revolution. A comprehensive data vision and strategy also empowers the government when it needs to move quickly to adapt and react to the ever-changing technological landscape. When we need swiftly to harness new technologies or developments, we risk missing out and needlessly delaying if we drive ourselves back to the legislation table each time. While I'm greatly enjoying this bill committee, if we go through a full set of legislative processes every time we want to make use of the latest innovation, then we will move far too slowly. And an overarching vision gives confidence to the government in how to react to new developments by assessing how they can match up with long-term strategic goals that they want to achieve. Our slow adoption of the power of data has allowed many other countries to be leaps and bounds ahead of us, despite not having the resources or the expertise or the talent that our country has heaps of. Let's make sure that for the next step of digital transformation, people look to us as leaders and trailblazers. I hope the government will take inspiration for this data vision and strategy from the last 25 years in Estonia. As I told the House at second reading, Estonia has made the astonishing transformation from a poor post-Soviet state to a leader in digital government and data leadership. Their national drive to improve digital literacy and access, along with pulling their public services into the digital age, is an example which many other nations, including ours, should seek to follow. They have made 100% of public services available digitally, developed the fantastic X-Road data sharing platform, and delivered millions of euros in efficiency savings. It's a completely realistic goal to make the UK a leader in digital government and data efficiency, just like Estonia. That's the goal that I would write in the government's data vision. I hope that the Minister, if he were authoring it, would be just as ambitious. I also think the government could take lessons from Denmark, which has come top of the UN's e-government rankings. They've embedded core principles of digital inclusion into their data and digital transformation journey. These principles include being aware of the consequences of digitization, providing usable alternatives, and designing solutions for all citizens. I think it's this quote from their Principles of Design and Digital Inclusion publication that's particularly pertinent, and I quote, "It is a democratic problem if the digital transformation becomes a barrier to participating in the welfare society." The Minister I have spoken about and shared concerns around digital exclusion. It's something which our constituencies and constituents both have in common. I hope he would be as keen as me to see this inclusion principle made a key tenet of the future of digital governance and data use. Amendment 21 also ensures that in drafting and delivering this strategy, the government can rely upon the expertise of the Information Commission. The rights and freedoms of citizens, their data ownership must be core to a future data vision and strategy. So this amendment enshrines the ability of the Information Commission to act as a source of advice and guidance in bringing this forward. The government and its departments will need to be ready to implement the data vision and strategy and the radical transformation that it will require. It's for this reason that I've tabled new clauses 11 and 16. New clause 11 requires the NHS and government to ensure the appointment of someone with a senior data, information or technology role to their boards. I had a helpful inspiration for the drafting of this amendment, the government's very own and very recently published State of Digital Government Review, tabs for reference, published only a couple of months ago. The review is nothing short of excoriating in its assessment of the current state of digital government, as well as the government's digital talent and culture. The review states, and I quote, "Non-digital public sector leaders with sizable delivery responsibilities have insufficient technical expertise or training." It also states that digital leadership is not a consistent priority. My new clause would ensure that a chief digital and information officer, a chief information officer, a chief technology officer or service transformation lead is present on the boards of all government departments. As it stands, none of these roles are present on the Executive Committee at any of the following departments: Business and Trade, HCLG, Health and Social Care, Education, the Home Office, the Cabinet Office, NHS England and the Treasury. And I could keep going, but I think everyone gets the point. This is the government's own review, published by the Minister's Department, and I'm using it to help draw attention to the problem. It is criticising the problem that new Clause 11 seeks to remedy. So I'm inviting the Minister to accept this new clause to fix something that his own department has highlighted and that I wouldn't have known about without their very helpful review. I don't blame him, of course, one bit for this. His party have inherited this situation from the Conservatives, who were guilty of failing for almost a decade to address this problem. But I hope he can put this right by accepting new Clause 12. Turning back to his department's review, it also states that 47% of central government services and 45% of NHS services still lack a digital pathway. The report says the UK is under-digitised, and I wholly agree with it. I hope that new Clause 16 can take steps to fix this, and I would look forward to seeing the Secretary of State coming to Parliament with his review each year to tell us about the great leaps the government are making towards improved data use in public service delivery and improving their digital talent and culture. If the government is serious about pushing forward digital transformation with the power of data, then this new clause provides them with an annual victory lap. But if things are falling behind, if the problems that the State of the Digital Government Review identified are not being rectified, then it ensures they can be scrutinised and held to account. We can't let the government fall into the state that this review has found it to be in again. My new clauses can, I hope, fire the starting gun on a government which is ambitious and innovative about its data use and digitisation in the future. These are many of the same arguments that the Minister heard me make at second reading, and I was pleased with the warmth of his reception then, as well as the broad understanding from his department that we do need to do more and do it better. I hope he can provide me with some commitments today around the issues that I've raised for the benefit of the citizen experience and of everyone that we represent. I'll end by quoting from the conclusion of his department's review, which sums up the points I've made excellently, and I'm grateful to the government for publishing these findings. It says, "Digital is one of the most powerful forces for public service reform, and when it's successful, it changes lives and the public experience of government. However, our approaches to leadership, to structure, to measurements, to talent and funding do not yet do justice to this potential. It's time to transform and reform the way we do digital." Thank you.
Yeah.
Amendment 21 proposed to clause 117 as on the amendment paper. The question is that the amendment be made. Minister.
Mr Turner, I note that before the break we were with the Sugar Babes and now with the Tempest. I think he managed to get in a very brief quote from the Tempest, "O brave new world." I guess his version is "O brave new world that has such data in it." He excoriates the government for moving too slowly and for being in a position where we are not taking enough powers to ourselves to be able to move faster, and yet several of the amendments that the Liberal Democrats have tabled to this bill have been ones that insist that we should actually have more accountability to Parliament and a slower process and shouldn't have such regulation-making powers. Now, it's quite often difficult to decide between those two because you want to have enough parliamentary scrutiny, but in an area of technical change, rapid technological change, it's important that legislation is able to move fast enough to be able to adapt. He quite rightly refers to digital inclusion as a key aspect of, if you're going to take forward a digital nation, a digital government plan, you've got to factor in the fact that some people are simply not going to be able to take part in that at the moment unless you take radical action to include them digitally. Now, his 4 amendments, 21, new clause 10, new clause 11, new clause 16. The first gives a duty to the Information Commissioner. The second sets out a data vision and strategy. The third insists that departments must have somebody who is able to bring forward a data vision and strategy. And the final one insists that the Secretary of State produces an annual review. I haven't counted the number of annual reviews that the Liberal Democrats have tabled for the Secretary of State to produce as a result of the bill, but it's quite a large number already, and it may be a good idea if we just produce one review on an annual basis in this whole sector. And the blueprint for modern digital government, which we laid in Parliament on the 21st of January, addresses some of the concerns in these amendments. It aims to unify public services, strengthen digital and data leadership, create a national data library and ensure transparency. And a key commitment of that is the publication of a government digital and AI roadmap this summer to drive public sector reform, which will probably look remarkably like a data vision and strategy. So I think he's going to get what he wants. It's just that it's not going to have his title on it. I don't mean his name, I mean his title on it. But we are basically doing what he's intending to do. And I think if we were to add this to the bill, it would simply duplicate the work. We've also committed that the roadmap will be developed in the open, seeking input and collaboration from colleagues across central government, the wider public sector, civil society and tech companies, and that would include engagement with the Information Commission as proposed under his Amendment 21. In that context, we believe that there's no need to create a statutory obligation for the new Information Commission to provide advice. As for Amendment New Clause 16, the Government is dedicated to delivering data-powered public services which are built around users. Privacy notices and data sharing agreements ensure transparency, protecting individuals' rights while enabling efficient public services. And the Digital Economy Act 2017 gives government powers to share data across organisational boundaries to improve delivery of public services subject to privacy safeguards. There are many transparency measures that support this framework. He's right that we've gone far too slowly. It would be good if this data bill had actually been on the statute book several years ago. We nearly managed to get it over the line just before the general election in large measures. But I'm just not sure that an annual review of the use of the public service delivery data sharing powers presented to the board and ministers for endorsement would be particularly valuable. I hope that I've shown that this addition to the legislation is unnecessary, so I hope the member will not be pressing his amendments to a division.
If no one else is looking to catch my eye, I'll call the mover, or rather Victoria Collins, I think, is looking to speak.
Thank you, Mr. Turner. I turn to Amendment 52, but I would like to say I hope that. Oh, sorry.
Oh, sorry. Previous amendment. Are you looking to press the amendment or withdraw?
I'll withdraw.
For everybody's content, the amendment to be withdrawn.
Aye.
Amendment by leave withdraw. So now go to there.
Yes.
We now come to clause 117 stamp part, with which it will be convenient to also consider amendment 52, schedule 14 and clauses 118 to 120 stamp part. The question is that clause 117 stamp part of the bill.
Formally.
The question is that clause 117 stamp part of the bill as many. Sorry. You want to speak on it? Shadow Minister.
Thank you. I speak to clause 117, which is the first opening clause in Part 6 of the bill to reform the Information Commission. Part 6 sets out provisions to abolish the Information Commissioner's office and transfer its functions to a new body, the Information Commission, with a chief executive and board of directors. His Majesty's Opposition welcomes that the government is substantially taking forward some measures on the reform of the ICO envisaged by previous iterations of this bill and the DPDI bill of the last government. Indeed, the ICO has said that the changes in this bill will bring its government structure into line with that of comparable regulators. Given some of the challenges and opportunities our data-driven economy will present, it's right that the new Information Commission is set up in the right way to perform its regulatory functions as effectively as possible. There's no doubt that the scope of the Information Commission's role will grow commensurate with the changes brought in by this bill. For example, the obligation to have regard to factors such as promoting innovation and competition in the performance of its role. We are supportive of these aims, but it would be helpful if the Minister could address briefly some of the concerns raised by my noble friend Lord Holmes of Richmond in the other place, particularly speaking to his strategy for ensuring that the Information Commission is provided with clarity as to its responsibilities and obligations when it comes to economic growth, and how he will ensure this remains consistent with the Information Commission's primary functions relating to data protection.
Thank you, Mr. Turner. I will speak briefly around clause 52, but I'd like to think that after today and all of the Liberal Democrat interventions, no one will have any doubt that we take data very seriously. And I realise that we've outlined a lot of proposals, but they're all in the spirit of actually helping to try and shape and say how important we feel that data vision is. And again, Amendment 52 is just about that questioning over scrutiny. I'm very happy to withdraw that amendment, but again, it's about making sure we have that trust in line with innovation. Thanks.
Thank you. So on Amendment 52, the Government is, of course, committed to the independence of the ICO, and as the Honourable Member says, these recommendations about the changing of the structure were entirely ones that were advanced in the previous version of the bill and supported by the previous Government. We think that it would just make it more efficient, more effective, more transparent. We are committed to the ICO's independence. It's a vital part of their role. This is why the new role of the Chair of the Information Commission will be appointed by His Majesty by letters patent. This is the same approach taken for the current Information Commissioner role. Furthermore, the Secretary of State has agreed with the Chancellor of the Duchy of Lancaster that this role will be listed as a significant appointment with the Commissioner for Public Appointments and be subject to pre-appointment scrutiny by the Science, Innovation and Technology Commons Select Committee. I think the questions that the Shadow Minister raised about how can the Information Commissioner balance these two requirements are perfectly legitimate ones. I think they're ones for the Information Commissioner, and they're the kind of questions that could perfectly legitimately be asked in a pre-appointment session with the Science, Innovation and Technology Commons Select Committee. I don't therefore believe that the Honourable Lady's amendment is necessary. Mr. Turner, it might be useful, however, if I make just one other point, which is I'd like to put on record that the Government intends to maintain the title of the Information Commissioner in respect of the Chair of the Information Commission. This is in acknowledgement of the fact that the identity and brand of the Information Commissioner is valued and recognised domestically and internationally, and we don't want to lose that, so we intend to preserve it.
The question is that clause 117 stand part of the bill. As many as our opinion say aye.
Aye.
Contrary, no. I think the ayes have it. The ayes have it. Amendment 52, Schedule 14, has already been debated. Does Victoria Collins wish to move formally?
No.
Thank you. Amendment 52, proposed Schedule 14, as of the amendment paper. The question is that the amendment be made. As many as are of that opinion say aye. Of the contrary, no. I think the ayes have it. The ayes have it. We now come to the question on Schedule 14, which we've just debated. The question is that Schedule 14 is the 14th schedule to the bill. As many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. We now come to the question that clauses 118 to 120 stand part, which we've just debated. With leave of the committee, I'll take the decision on these clauses together. The question is that clauses 118 to 120 stand part of the bill. As many as are of that opinion say aye.
Aye.
Of the contrary, no. The ayes have it. The ayes have it. We now come to clause 121 stand part, with which it will be convenient to also consider new clause 3, Government Amendment 14 and Schedule 15. The question is that clause 121 stand part of the bill. Minister.
Mr. Turner, I beg to move that clause 121 and Schedule 15 stand part of the bill. They make clear that information standards published under Section 250 of the Health and Social Care Act 2012, as amended by the Health and Care Act 2022, will include standards relating to information technology or IT services used or intended to be used in connection with the processing of information related to the provision of health and adult social care in England. For the health and adult social care system to work effectively, data needs to be processed in a standardised way using common specifications, and this goes to some of the points that were made earlier by the Honourable Member who was quoting government publications. These provisions are an important step towards creating a modern health and adult social care service where systems are integrated and staff have quicker access to patient data, freeing up time that can be spent with patients. I mean, several members have referred in previous debates to the fact that one hospital I've referred to, I think previously, in Doncaster, employs 42 members of staff solely to carry around physical medical records. And there are still departments in many parts of the NHS in England which are producing more physical, handwritten notes every day of the week. That must be a nonsense. It must make it more difficult for us to be able to deliver connected services into the future. That can't be in the interests of the patient, because you would want the patient to be able to hold in their hand, in an app, everything that relates to their own medical health, almost like a medical passport of their own. That simply isn't possible if all the different bits of the NHS in England can't work together. We have tabled our own government Amendment 14, which is a technical change to ensure that any personal data processed in the exercise of the public censure power set out in Schedule 15 is subject to the relevant existing data protection legislation. And if I just refer to the opposition amendment, new clause 3, this would require that researchers keep and publish records about the health and social care data they process for research. There are already extensive transparency requirements for health data, and the Information Commissioner's Office provides detailed advice to the public on their data rights. The law only allows confidential patient information to be used for research without consent when it has been approved by the Health Research Authority. There are detailed arrangements for this approval based in law, and the transparency arrangements include published registers of approved applications showing what data is used, for what purpose and by whom. I hope, therefore, that the Honourable Lady will accept that this means her amendment is not necessary.
Shadow Minister, Dr. Ben Spencer.
Thank you. So this part of the bill is a concatenation of different provisions relating to data, which is one of the reasons why I think this bill is so glorious, because it covers such a wide range of scope of things to sort out. And I have to say, speaking to, in this section, I know there's we're going to debate some more deeper some parts later, but I'm quite glad to start off by speaking to clause 121, which is, as a former doctor, and I think I know as well, my wife is a doctor too, I particularly welcome the provisions and the opportunity that in making sure health data can be shared properly can provide. And I would say to the Minister, the issue isn't merely carrying around patient notes. Certainly my experience is the patient notes turning up in the first place at all. And as somebody who doesn't work in the health service anymore, I see the other side, which is the situation where the burden is on the patient quite often to provide their notes or to give repeatedly information which different parts of the system have. Surely that is a wholly inefficient way of doing things, and one of the benefits of having the NHS as set up as it is surely must be the ability to have coherent approaches to sharing of data, so that we don't have this situation with notes. And it's not merely an inconvenience, it's also patients can be exposed to repeated tests, repeated imaging, all of which have a degree of iatrogenic harm and risk, plus delays into going forwards. And when it comes to patients who, certainly in my former field of work in terms of psychiatry, certainly the places that I worked at, psychiatrists are very quick to adopt electronic patient records, noting how important it is, that data sharing, but also the risk of re-traumatising people when repeated disclosures around traumatic events are required. In part, I worry in part because that data isn't shared as effectively as it could be. I raised in the Chamber at the second reading of the bill that changes in this area will need to be supported by ensuring that hospitals and healthcare settings have access to IT of sufficient quality to support these new systems. Can the Minister provide an update on his strategy? I don't recognise it's not precisely his strategy, it's shared with the Department of Health and Social Care, on renewing NHS IT infrastructure, ensuring necessary kit is put in place to ensure these provisions can be rolled out to maximum advantage. So not merely the sharing of the data, but the requirement that it no longer is necessary to fax information, and we have the computer infrastructure for data sharing necessary.
Victoria Collins.
Thank you, Mr Turner. I will speak specifically around new clause 3. This, again, is in light of, obviously, this question of trust. I know that even the British Medical Association have highlighted concerns over transparency and making sure that we unlock that innovation and bringing that data, i.e. people are willing and ready and happy to actually be part of this. So that's why new clause 3 highlights that health and social data, when used for research, should have kind of clear data categories are properly recorded, and the individuals have a right to understand how their data is used. I do appreciate, however, the comments from the Minister, and I'm happy to withdraw that clause.
I'll be brief in replying to the... very brief. He nearly caught me out because I had to look up iatrogenic. But basically, I think it means that when you're being treated for something, that sometimes it can lead to harmful effects. I'm worried about this because I've got a PET CT scan tomorrow afternoon and an MRI scan on Saturday. So I'm worried that I'm being subjected to more risk because of all this imaging. But the truth of the matter is, you want to be, as a patient, you want to be able to access as many of your records as possible, whether it's your blood tests or whatever. That's a significant change that's happened in the last few years. It's about putting the patient back in a key role in the NHS, being able to manage their own data. But that simply cannot happen unless we bring this legislation forward and we get to rolling out changes across the whole of the NHS. Now, he asked me a specific question, and he admitted that it wasn't really what is my plan to develop these things. I think I'm going to have to write to, or I might have to get the Department for Health and Social Care to write to him to lay some of that out. It's part of the work that we need to do at the moment, and in fact, I have it's not in this bill, but as a Welsh MP, I'd quite like to be able to see us have shared standards across the whole of the United Kingdom, because there are people who are using different parts of the NHS across the whole of the United Kingdom, and that would make simple common sense. I also worry sometimes about the cyber security of every different part of the NHS buying its own little bit of systems, and whether all of those therefore have the necessary cyber security to make sure that data is preserved safely, and I wonder whether I believe that what we're doing in the bill will enable us to get to a much more secure set of data provisions around the way health information can be shared between different parts of the NHS in England.
The question is that clause 121 stand part of the bill. As many as are of that opinion say aye. Aye. The contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 14 to Schedule 15, which has just been debated. The question is that the amendment be made. As many as are of that opinion say aye. Aye. The contrary, no. I think the ayes have it. The ayes have it. We now come to question on Schedule 15 as amended, which we have just debated. The question is that Schedule 15 as amended be the 15th schedule to the bill. As many as are of that opinion say aye. Aye. The contrary, no. I think the ayes have it. The ayes have it. We now come to clause 122 stand part, with which it will be convenient to also consider Schedule 16. The question is that clause 122 stand part of the bill.
For me.
Minister. The question is that clause 122 stand part of the bill. As many as are of that opinion say aye. Aye. The contrary, no. The ayes have it. The ayes have it. We now come to the question on Schedule 16, which we have just debated. The question is that Schedule 16 be the 16th schedule to the bill. As many as are of that opinion say aye. Aye. The contrary, no. The ayes have it. The ayes have it. We now come to clause 123 stand part. The question is that clause 1, 2, 3 stand part of the bill.
Formally.
The question is that clause 1, 2, 3 stand part of the bill. As many as are of that opinion say aye.
Aye.
The contrary, no. The ayes have it. The ayes have it. We now come to clause 1, 2, 4 stand part, with which it will be convenient to also consider new clause 29. The question is that clause 1, 2, 4 stand part of the bill. Minister.
Mr Turner, I beg to move that clause 124 stands part of the bill. This delivers on our Labour manifesto commitments to further support coroners and the Procurator Fiscals in Scotland to access information held by online services after a child's death. This is obviously a very sensitive issue and we've tried to address it as such. The provision will require Ofcom, when informed by a coroner, to issue a data preservation notice to specified online service companies. This will help to ensure those online service companies retain all relevant data they have on a child so that it will be available upon request should a coroner later require it as part of an inquest into a child's death. This clause demonstrates the government's commitment to keeping children safe online and to supporting families who have endured unimaginable losses. I'm conscious that there are those who might want us to go further, and further to the conversation we had a little bit earlier, that might be a discussion that we could fruitfully have before we get to report stage. Regarding amendment new clause 29, let me just reassure the honourable member that there are already strong powers to ensure that companies comply with data preservation notices. This includes the power to issue fines for non-compliance of up to £18 million or 10% of qualifying worldwide revenue, and the ability to hold senior managers criminally liable for non-compliance. These sanctions will help ensure online services comply with any notice issued under Section 101 of the Online Safety Act. The Secretary of State must also already review the effectiveness of the Online Safety Act regime. That's a provision in the Online Safety Act, which will include the data preservation measures between 2 to 5 years after it comes into force. The Secretary of State must produce a report detailing his findings, which will then be laid in Parliament. I therefore hope that the honourable member will not feel the need to push her amendment to a division.
Shadow Minister Dr Ben Spencer.
Thank you. All I just wanted to put on record, obviously we because of the nature of this debate, can't speak to new clause 30, but I do hope that when we get to report stage, there's ample opportunity for further discussion on this broader issue, which is, of course, of great importance.
Thank you, Mr Turner. Clause 124 is a provision concerning the retention of information by internet service providers, as mentioned in the deeply tragic event of a child's death. This clause rightly acknowledges the potential need to access such data for crucial investigations and to understand the circumstances surrounding such loss. However, mere provision for data retention is insufficient without a mechanism to ensure its effective implementation and alignment with broader online safety efforts. This is why we've proposed new clause 29, which ensures government oversight by requiring the Secretary of State to publish a compliance report within 12 months. The report will assess whether social media platforms, including Category 1 services under the Online Safety Act 2023, are preserving data when needed for investigations, regulatory actions and legal proceedings, and I do appreciate the comments from the Minister. I'd also expand to say that although it's not in this bill, this is also an opportunity to highlight that Liberal Democrats believe Category 1 services should not be linked to the size of online platforms alone, but also platform functionality and other characteristics would determine whether a regulated provider would be classed as Category 1 or Category 2. We know that harmful content, abuse and illegal activity leave a digital footprint, but without that enforcement, key evidence may be erased before authorities can act. And this clause ensures that platforms are held accountable, preventing data from being lost if needed. It's not just about policy, but it's ensuring that social media companies meet their legal obligations and that enforcement is transparent and effective. But once again, I appreciate the open discussion that the Minister has put forward around these issues.
The question is that clause 124 stand part of the bill. As many as are of that opinion say aye. Aye. Contrary, no. The ayes have it, the ayes have it. We now come to clause 125 stand part. The question is that clause 125 stand part of the bill.
Formally.
The question is that clause 125 stand part of the bill. As many as are of that opinion say aye. Aye. Contrary, no. I think the ayes have it, the ayes have it. We now come to clause 126 stand part, with which it will be convenient to also consider amendment 54, clause 127 and clause 128 stand part. The question is that clause 126 stand part of the bill.
I'll move formally, but I'm happy to respond to the debate on the amendment afterwards.
Thank you, Mr. Turner. I will say that I didn't realise we'd be debating all of these today, so I appreciate that my voice is probably loud and clear today. It wasn't the original intention. But these are important issues. Clause 126 addresses the sensitive issue of biometric data retention, particularly for law enforcement purposes. Amendment 54 strengthens safeguards by requiring a judicial review mechanism before data can be retained beyond a defined period, and that's where we are just raising the alert in it's making sure that there is a defined period and that there is cause to make sure that actually it's not kept beyond that. So it's crucial protection to prevent undue encroachment on civil liberties. The use of biometric data must be carefully regulated to prevent misuse and overreach. While we acknowledge the role of such data in tackling crime, we must ensure that retention policies are both proportionate and necessary. So our Amendment 54 aligns the UK's approach with best practices, ensuring that security does not come at the cost of fundamental rights.
Mr. Turner, I thank the Honourable Lady. She's tabled another amendment which calls for the Secretary of State to report to Parliament. And I just would gently suggest to her that some of these reports, I hope I'm proving, are unnecessary, or the requirement to put it on the face of the bill are unnecessary. Her amendment would introduce a new duty on the police to review the retention of biometric data under Clause 127 and a duty for the Secretary of State to report to Parliament on the use of this data. Clause 127 does not alter the existing duty in the Data Protection Act 2018, which ensures that the police only retain personal data, including sensitive personal data such as biometrics, as long as it is considered necessary and proportionate, precisely the terms that she advocated. The Biometrics Commissioner already has independent oversight of biometric data retained under the Counter-Terrorism Act 2008 and has a statutory duty to report to Parliament annually. The Independent Reviewer of Terrorism legislation also has statutory oversight of all the powers in the Counter-Terrorism Act 2008 and reports annually to Parliament. And for those reasons, not doubting the Honourable Lady's intent, I hope she will consider withdrawing the amendment.
The question is that clause 126 stand part of the bill. As many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. Amendment 54 to clause 127 has already been debated. Does Victoria Collins wish to move formally?
No, I'm happy to withdraw.
Thank you. We now come to the question that clause 127 and 128 stand part, which we've just debated. With leave of the committee, I'll take the decision on these clauses together. The question is that clauses 127 and 128 stand part of the bill. As many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. We now come to clause 129 stand part, with which it would be convenient to also consider clauses 130 to 134 stand part. The question is that clause 129 stand part of the bill.
Formally.
The question is that clause 129 stand part of the bill. As many as are of that opinion say aye.
Aye.
The contrary, no. I think the ayes have it. The ayes have it. We now come to question that clauses 130 to 134 stand part, which we've just debated. With leave of the committee, I will take the decision on these clauses together. The question is that clauses 130 to 134 stand part of the bill. As many as are of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. The ayes have it. We now come to the question that clauses 135 stand part, which was debated with clause 95. The question is that clause 135 stand part of the bill. As many as are of that opinion say aye.
Aye.
Contrary, no.
No.
Division. The whip's happy. Lock the doors.
Callum Anderson.
No.
Steph Apperon.
Aye.
Danny Beals.
No.
Chris Bryant.
No.
Victoria Collins.
Aye.
Kate Dearden.
No.
Kira Flintwhistle. Peter Fortune. Warinder Juss. Sonia Kumar. Alice MacDonald. Alex McIntyre. Ben Objective.
Abstain.
John Pearce.
No.
Joe Robertson.
Stay.
Gurinder Singh Josan. No. And Dr. Ben Spencer.
Abstain.
The ayes were 2 and the noes were 9, so the noes have it. We now come to the question that clauses 136 stand part, which was debated with clause 95. The question is that clauses 136 stand part of the bill. As many as are of that opinion say aye.
Aye.
Of the contrary, no.
No.
Division. Whip's happy? What were those?
Callum Anderson.
No.
Steph Acheron.
Aye.
Danny Beales.
No.
Chris Bryant.
No.
Victoria Collins.
Aye.
Kate Dearden.
No.
Kieran Whistle. Peter Fortune.
Abstain.
Warinder Juss.
No.
Sonia Kumar.
No.
Alex McIntyre.
No.
Ben Obsujecti.
Abstain.
John Pearce.
No.
Joe Robertson.
Abstain.
Gurinder Singh Josan.
No.
And Dr. Ben Spencer.
Abstain.
The ayes were 2, the noes were 9, the noes have it. We now come to the question that clauses 137 stand part, which was debated with clause 95. The question is that clauses 137 stand part of the bill. As many as are of that opinion say aye.
Aye.
Of the contrary, no.
No.
Division. Whips, happy. What were those?
Callum Anderson.
No.
Steph Acheron.
Aye.
Danny Beales.
No.
Chris Bryant.
No.
Victoria Collins.
Aye.
Kate Dearden.
No.
Peter Fortune.
Abstain.
Warinder Juss.
No.
Sonia Kumar. Alex McIntyre.
No.
Ben Obsujecti.
Abstain.
John Pearce.
No.
Joe Robertson.
Abstain.
Gurinder Singh Yusan.
No.
And Dr. Ben Spencer.
Abstain.
The ayes were 2, the noes were 9, so the noes have it. We now come to the question that clauses 138 stand part, which was debated with clause 95. The question is that clause 138 stand part of the bill. As many as are of that opinion say aye.
Aye.
Of the contrary, no.
No.
Division.
Callum Anderson.
No.
Steph Acheron.
Aye.
Danny Beales.
No.
Chris Bryant.
No.
Victoria Collins.
Aye.
Kate Dearden.
No.
Peter Fortune.
Abstain.
Warinder Juss. Sonia Kumar. Alex McIntyre.
No.
Ben Obsujecti.
Abstain.
John Pearce.
No.
Joe Robertson.
Abstain.
Gurinder Singh Yusan.
No.
And Dr. Ben Spencer.
Abstain.
The ayes were 2, the noes were 9, so the noes have it. We now come to the question that clauses 139 stand part, which was debated with clause 95. The question is that clauses 139 stand part of the bill. As many as are of that opinion say aye.
Aye.
Of the contrary,
No.
Division.
Callum Anderson. Steph Acheron.
Aye.
Danny Beales.
No.
Chris Bryant.
No.
Victoria Collins.
Aye.
Kate Dearden.
No.
Peter Fortune.
Abstain.
Warinder Juss. Sonia Kumar. Alex McIntyre.
No.
Ben Obsujecti.
Abstain.
John Pearce.
No.
Joe Robertson.
Abstain.
Gurinder Singh Yusan.
No.
And Dr. Ben Spencer.
Abstain.
The ayes were 2, the noes were 9, so the noes have it. We now come to clause 140 stand part. The question is that clause 140 stand part of the bill. Minister.
I beg to move that it not stand part of the bill. Mr. Turner, clause 140, which was tabled in the House of Lords, is a regulation-making power that would enable terms relating to core personal data attributes to be defined consistently across data held by public authorities. The intention behind this amendment is that the power could be used to define the term sex. We seek to overturn this clause for the following reasons. The government believes that public sector data, including data about sex and gender, should continue to be collected based on the specific data requirements of those collecting the data and their users, which differs across contexts. This is in line with the data minimisation principle set out in the data protection legislation. We do not think it appropriate to have core personal data attributes defined in regulations in the way proposed. Furthermore, setting out such definitions using secondary legislation could create confusion where terms are already defined in legislation and could, depending on the approach taken, cut across those existing definitions. For example, defining sex could cut across the existing legal framework and undermine protections in the Gender Recognition Act 2004 and the Equality Act 2010. However, I am keen to reassure my honourable friends that the government recognises the importance of harmonising data and has already commenced important work on standards across government via a cross-government working group led by the Data Standards Authority that will define the core attributes of a person. The Office for Statistics Regulation has also last year published guidance on collecting and reporting data about sex and gender identity, and the Government Statistical Service published a work plan for harmonised standards in this space in December 2024. It is the Government's belief that these matters are crucial and more appropriately considered holistically outside of this bill. The intention of this bill is not to define or remark on the definitions of sex and gender or other core personal data attributes. I therefore beg to move that this clause do not stand part of the bill.
Shadow Minister, Dr Ben Spencer.
Thank you. So as the Minister noted, Clause 140 is a provision that was introduced in committee in the other place along with clauses 28.3, 4 and 45.6, which have now been removed from the bill pursuant to a vote of this committee. Clause 140 goes to the aim of ensuring the accuracy of data underpinning digital forms of verifying identity and more broadly. It is, of course, a degree sort of an irony that we are finding ourselves living in a world where we have to have a debate over data dictionaries when it comes to definition of sex. But I think the point about data dictionaries more generally, over and above the focus which will be on sex data in this debate, I think is nevertheless sound. We are aware of the government's argument that the clause is inserted in the other place pertaining to data accuracy. In particular, clause 45.6 is not compatible with certain provisions of the ECHR and the Gender Recognition Act 2004. I'm grateful to the Minister for writing to the committee on this and amongst other matters, but I don't think his explanation gives any rationale on that basis for the removal of this clause. While we strongly disagree with the government's position on this, for the reasons I set up last week, I'm not going to rehash those arguments now. Rather, I want to make a simple argument in favour of retaining a clause on data dictionaries that the government intends to remove. Clause 140 grants the Secretary of State the power to make regulations establishing the definitions and associated metadata for core personal data attributes. The Secretary of State may require that these definitions are used for, amongst other things, personal data recorded by public authorities, clause 141D, and the Digital Verification Service, clause 141A. My noble friend, the Lord Lucas, stated the case in support of his data dictionary amendment compellingly in the other place, saying, if we are to live in a data-rich world, we really need a set of well-understood, good definitions for the basic information we are collecting. It really is that simple. Given the Secretary of State the power to define these core personal data attributes so that a consistent approach can be taken across the board by public authorities and entities engaged in digital verification services. So my question for the Minister is, what is the objection for the Secretary of State having this power to clarify the meanings of these essential terms which we need to use to define data attributes? A clear definition of data attributes, and particularly the meaning of sex, is a foundational building block. A building block that will help ensure the data we collect can be harnessed for good quality research on which sound public policy decisions can be based. In the other place, the Minister for Decent, the Noble Lord Ballant of Balham, acknowledged the need for data to be both based in truth and consistent and clear. However, he opposed this clause on the basis that the government would prefer to consider the matter of data accuracy and consistency holistically outside the scope of this bill. In this regard, he pointed to ongoing research in the field, including the Sullivan Review of Data, Stats and Research on Sex and Gender, which was commissioned by the previous Conservative government, the findings of which this government would like to take into account in developing its policies in the area. Now, I welcome the fact that the government intends to take a closer look at the importance of data accuracy, especially in relation to the collection of sex data. But there's no need to kick the can down the road on this. Clause 140 compels the Secretary of State to do nothing. Well, not in a sort of actor sense, but there's no, only if. Clause, like I say, does not compel the Secretary of State, but it does give him the important power to put definitions of core personal data attributes in place once the important work of the Sullivan Review and other studies have been published and considered. And we have referenced a few times the amount of iterations that this bill has gone through and the long legislative period. So what we're saying is this is a provision which we think will be useful, if not essential, for resolving some of these issues. Getting these basic definitions right is essential. If we don't, mistakes can flow from it, and it can become entrenched in the records of public authorities. It can lead to skewed research findings on important societal matters such as health disparities and outcomes across the sexes, as well as employment opportunities and equal pay. For these and so many other good reasons, let's take this opportunity to get the basics right. In this regard, I'd encourage the Minister to heed the timeless words of Julie Andrews, with which he opened the committee stage. As far as definitions for core data attributes are concerned, let's start at the very beginning. It's a very good place to start.
Mr. Turner, I have confidence in confidence alone. I have confidence in you, if we're going to do Julie Andrews. This is obviously a serious matter because, look, the amendment is tabled. It's pretending just to be a regulation-making power, which would allow government to publish a data dictionary by regulations. But the truth is that the clause is framed as a means to promote data consistency. Its actual intent is to push government to set a single definition of the term sex through a public authority data dictionary, which public authorities would need to regard when processing data. As I've said several times in several debates already, I think that that's inappropriate. The whole purpose of data is that data is set within a context, and that context changes. So, for instance, the data that you would require in the running of a hospital and provide it, or in the running of a prison, is different, I would argue, for the data that you require in the hiring of a car or buying of a property. And that's why we think it's important that we don't go down this route. I note that the opposition is trying to give the Secretary of State more powers to do things by regulation, but I think it would be completely inappropriate to develop this by secondary legislation, which will be unamendable and therefore only subject to minimal debate. And as I say, yes, I completely agree with my noble Lord, Lord Valence, that the data has to be consistent and accurate, but it also has to be within the context for which it is being used. And I think that's the key determinant that members are not understanding from the argument that the government has made. Nonetheless, I still move that clause 140 do not stand part of the bill.
The question is that clause 140 stand part of the bill. As many as are of that opinion say aye. Aye. Of the contrary, no.
No.
Division. Whips, happy. Lock the doors.
Callum Anderson. No. Steph Eckleron. No. Danny Beals. No. Chris Bryant.
No.
Victoria Collins.
No.
Kate Dearden.
No.
Peter Fortune.
Aye.
Warren DeJus.
No.
Sonia Kumar.
No.
Alex McIntyre.
No.
Ben Obsejecti.
Aye.
John Pierce.
No.
Joe Robertson.
Aye.
Gurinder Singh Yosan.
No.
And Dr. Ben Spencer.
Aye.
The ayes were 4, the noes were 11, so the noes have it. The noes have it. We now come to Government Amendment 28 to clause 141, with which shall be convened to also consider Government Amendments 29 to 48 and clause 141 stand part. I call the Minister to move Government Amendment 28.
Mr. Turner, I beg to move that Government Amendment 28 and all the subsequent ones up to 41, all of which relate to clause 141. These amendments are the result of considerable discussions between different officials who suddenly joined me as my inspiration and the noble Baroness Owen. As promised in the other place, we've tabled further amendments to the offence that was included in the House of Lords. Recognising how crucial time limits are in this sensitive area, we made a commitment which is addressed by Amendment 38. This would extend the statutory time limit to enable prosecutions to be brought at any date which is both within 6 months from when sufficient evidence comes to the prosecutor's knowledge to justify prosecution and within 3 years from when the offence was committed. By doing this, prosecutions can be brought so that perpetrators do not get away with creating a deepfake just because no one knew about it in time for the prosecution to commence within 6 months. Through Amendment 31, we will ensure that the law comprehensively criminalises asking someone to create a deepfake for you, regardless of where they are based or whether the image was made. We absolutely agree with the policy rationale put forward by Baroness Owen, which is why we did not oppose the amendment on solicitation. Our amendments replace this term solicitation with a new requesting offence, which has been drafted to ensure that it is comprehensive and functions as it should do, and that it is clear to the courts how it should be understood and applied in practice within the wider criminal law framework. Through Amendment 30, we are reinstating a defence of reasonable excuse to the creating offence. This was part of the original government amendment and part of the noble Baroness Lady Owen's original amendments, and we believe that a defence is necessary for both the creation and the solicitation or requesting offence. We are clear that we do not wish abusers to be able to evade justice by using spurious excuses. However, the definition of images in this offence includes wider intimate images, such as those showing someone in underwear or using a toilet, even where these are not pornographic or sexual in any way and were not created to abuse a victim. This is a new offence, tackling relatively new behaviour, and this defence is needed to ensure that only culpable behaviour is criminalised and where it is in the public interest to do so. I would like to reassure honourable members that this defence is a common aspect of many criminal offences, this defence of a reasonable excuse. Offenders will not be able to use it to escape justice. It is not the case that they can simply assert an excuse and that will be deemed reasonable. They will need to prove with evidence that they have had such an excuse. The courts will then interrogate that to decide whether, in fact, the excuse was reasonable. Furthermore, it is our view that a defence of reasonable excuse is important to ensure compliance with freedom of expression principles. Clause 141 already ensures that in civil courts, deprivation orders will be available in respect of intimate image deepfakes where their creation constitutes an offence under Section 66E. Amendment 40 ensures that this will be the case within the service justice system. Clause 141 delivers our manifesto commitment, ensuring that those who create a deepfake intimate image of an adult without their consent or a reasonable belief in their consent can be prosecuted. There is no need to prove any other motivation. This offence will carry maximum penalty of an unlimited fine or 6 months imprisonment or both. Our clause will also ensure that the courts have the power to deprive offenders of the images they have created or the devices containing them. Creating intimate image deepfakes is a truly demeaning and disgusting form of chauvinism. We believe Clause 141, as amended, will tackle this behaviour. We're sending a very clear message to the perpetrators. They will be put on notice that they will face the full force of the law. I beg to move that the clause stand part of the bill and that the amendments be made.
Shadow Minister.
Thank you. I'd like to start by congratulating my noble friend Baroness Owen of Old Edge on her hard work and tenacity in raising the profile of the harms caused to victims of sexually explicit deepfakes and ensuring that clauses criminalising this activity were inserted into the bill in the other place. And we welcome very much the government's engagement in this important area and very broadly supportive of the government's amendments, which substantially deliver the changes to the Sexual Offences Act sought by the noble Baroness in the other place. In particular, we welcome the government's new clause under its Amendment 31, which substantially reflects the offence of solicitation under Clause 141 as drafted. Could the Minister, in his wider perhaps give a bit more flesh on the bones behind the reasoning and necessity for the substitution of the term solicitation, requesting instead of solicitation in this context in its new draft clause. Does he regard those terms as having equivalent meaning in this context, and if not, what's the material difference between the approach to terminology here? I'm thankful for the Minister's comment with regards to the reasonable excuse defence. However, I do have some questions around what exactly a reasonable excuse looks like in this context. Does he have any examples for our understanding what in these circumstances is a reasonable excuse? And based on that, does the government intend to publish guidance on the scope of this defence and its explanation? We're also pleased to see the inclusion of the Government Amendment 38, inserting, amongst other things, an extended limitation period of 3 years from the date of creation or request for creation of a purported intimate image for bringing criminal charges. This would increase the scope for victims to seek justice where these images come to light after some time has elapsed after creation.
Victoria Collins.
Thank you, Mr. Turner. We very much welcome the clauses 141 and an action that's taken about violence against women and girls, notably, including online. There is one point we would like to just ask the Minister a question on, because this one talks about creating or soliciting the creation of purported intimate image of adults, but also it doesn't necessarily deal with the sharing of. And it's a question to the Minister or something to think of in the future of how do we hold to account those who are sharing those images, which are also those intimate images which should not be.
Thank you, Mr. Turner. So I too should put on record, as the Shadow Minister did, my gratitude and congratulations to Baroness Owen for her tenacity. Absolutely right. Sorry, I wasn't sure whether the Honourable Lady was going to intervene on me.
No, I was just saying here to agree.
Oh, right, here. Right. Excellent, good, right. We all agree that Baroness Owen has done a great piece of work for us, and we're grateful. And I'm grateful, incidentally, to Ministry of Justice officials who work with decent officials to make sure that we've got these amendments that are before us today, which I think will make for a more comprehensive version of what was originally argued for. The Honourable Member asked me about the difference between solicitation and requesting. I mean, often it is considered that solicitation would require some form of exchange of money, and obviously we wouldn't want necessarily that to be the case in this, which is why requesting is a broader category than solicitation. A request includes doing an act which could reasonably be taken to be a request, such as, for example, nodding or otherwise indicating agreement in response to an offer or complying with conditions of an offer. It also includes both making a request directed to a particular person or persons and making a request available to one or more people, or people generally, without directing it to a particular person or people. In other words, that is broader than solicitation would have required. And I think Baroness Owen agrees with us that this is therefore a more comprehensive issue, the offence rather. He asked about the reasonable excuse example. A software for instance, let's say a software developer wants to ensure that he has built the right, or he or she has developed the right safeguards in, it probably would be he, I think in this case, in his software to stop people generating intimate deepfakes without consent of the person depicted. In some circumstances, he will have a reasonable excuse where, during the course of the testing, to ensure that the software does not create such images, he creates a purported intimate image. That might be, for instance, a reasonable excuse. I don't want to lay out what reasonable excuses might be, because the courts are so used to dealing with this concept of a reasonable excuse. There are many offences to which it applies, and the courts, as I say, are used to dealing with them. The Honourable Lady asked me about sharing. Is sharing a deepfake an offence? Sharing a deepfake intimate image without consent is already an offence under Section 66B of the Sexual Offences Act 2003. Mr. Turner, without any further ado, I hope that we can agree the amendments and the clause.
Government Amendment 28 proposed to clause 141. The question is that the amendment be made. As many as are of that opinion say aye.
Aye.
Of the contrary, no. The ayes have it ayes have it. We now come to the question that the government amendments 29 to 42 to clause 141 be made, which we've just debated. With the leave of the committee, I'll take the decision on these amendments together. Government amendment 29 to 42 proposed to clause 141. The question is that the amendment be made. As many as are of that opinion say aye.
Aye.
And of the contrary, no. I think the ayes have it. The ayes have it. We now come to the question that clause 141 as amended stamp part, which we've just debated. The question is that clause 141 as amended stamp part of the bill. As many as are of that opinion say aye.
Aye.
And of the contrary, no. I think the ayes have it. The ayes have it. We now come to clause 142 stamp part, with which it will be convenient to also consider clauses 143 to 146 stamp part, Government Amendment 16 and clause 147 stamp part. The question is that clause 142 stamp part of the bill. Yes,
I beg to move that all the clauses stand part, and also to move Amendment Government 16. I'll only really speak to the last bit. This is highly technical, and there will be a test on it afterwards. Amendment Government 16 removes the privilege amendment, which was inserted at Lord's third reading to clause 147, which was necessary given the bill was introduced in the Lords. Otherwise, I beg to move that clauses 142 to 146 and 147 stand part of the bill.
So the question is that clause 142 stand part of the bill. As many as are of that opinion say aye. And of the contrary, no. The ayes have it, the ayes have it. We now come to the question that clause 143 stand part, which we have just debated. The question is that clause 143 stand part of the bill. As many as are of that opinion say aye.
Aye.
Of the contrary, no. The ayes have it. The ayes have it. We now come to the question that government amendments 43 to 47 to clause 144 be made, which we've just debated. With the leave of the committee, I'll take the decision on these amendments together. Government amendment 43 to 47 proposed to clause 144. The question is that the amendment be made. As many as are of that opinion say aye.
Aye.
And of the contrary, no. I think the ayes have it. The ayes have it. We now come to the question that clause 144, as amended, stand part, which we've just debated. With leave of the committee, I'll take the decision on these clauses together. The question is that clause 144, as amended, stand part of the bill. As many as are of that opinion say aye.
Aye.
And of the contrary, no. I think the ayes have it. The ayes have it. We now come to the question that clause 145 to 146 stand part, which we've just debated. With the leave of the committee, I'll take the decision on these clauses together. The question is that clauses 145 to 146 stand part of the bill. As many as are of that opinion say aye.
Aye.
And of the contrary, no. The ayes have it. The ayes have it. We now come to the Government Amendment 16 to clause 147, which has been debated. The question is that the amendment be made. As many as are of that opinion say aye.
Aye.
And of the contrary, no. I think the ayes have it. The ayes have it. We now come to the question that clause 147 as amended stand part, which we've debated. The question is that clause 147 as amended stand part of the bill. As many as are of that opinion say aye.
Aye.
And of the contrary, no. I think the ayes have it. The ayes have it. We now come to the new clause 1, which has already been debated with clause 80. Victoria Collins to move formally.
No, it has to be brought.
We now come to new clause 2. Call Victoria Collins to move.
Thank you, Mr. Turner. As a Liberal Democrat, it'll be no surprise that we support greater collaboration with our European partners. Local people and businesses across Harpenden and Berkhamsted, as well as up and down this country, continue to highlight the importance of working with the EU and indeed for ever closer union. New Clause 2 seeks to ensure that any changes in our data laws or international commitments do not jeopardise our data adequacy, which is due to be reassessed by the EU in June of this year. And I do know that the Minister is very much, that's possibly why we're pushing through this bill, to make sure that we get it in line with that. But this is indeed crucial because the UK's ability to transfer data internationally underpins business, research and security partnerships. That data adequacy is what allows personal data to flow freely between the UK and the EU without the need for costly and complex additional safeguards. Indeed, a report by the New Economics Foundation put the cost of non-data adequacy with the EU at between 1 to 1.6 billion for British businesses, highlighting the importance of aligning with our European neighbours on this important topic. The UK is also party to various international agreements and conventions relating to data protection. This clause ensures that we assess how our international commitments may impact the EU's view of our data protection framework. If we fail to maintain strong data protections, we risk losing our EU data adequacy status, an outcome that could cost billions in compliance burdens, disrupt cross-border operations and hinder UK businesses from accessing global markets. It would be a hammer blow to the UK businesses, particularly SMEs, which rely on seamless data exchange with our European partners. So supporting new Clause 2 is about ensuring that Britain continues to lead on data governance, innovation and global collaboration. Data adequacy is not just a legal issue, it is a fundamental element to maintaining economic growth, international trust and our competitive edge. We welcome assurances and indeed already discussions I've had with the Minister that the government, that data adequacy with Europe is maintained.
New Clause 2, impact of this Act and other developments at national and international level on EU data adequacy decision.
The question is that new Clause 2 be read a second time. Shall the Minister?
Thank you. I just wanted to make 2 points, which was a bit confused by the timings in terms of this new clause. I think we all agree on the importance of data adequacy, but 3 months post-royal assent, at the point which my understanding is we already will have had to have had a data adequacy agreement in place, given the times it would take to get royal assent. The other point I just wanted to make is I think this might be the last time I get to speak on behalf of His Majesty's Opposition during this Bill Committee, and just to thank members and officials in the Chair taking a part in this, and look forward to further debate at the report stage.
Minister.
First of all, Mr Turner, I should have also said thank you to my honourable friend, the Minister, Department for Justice, the member for Pontypridd, because I know she's been intimately involved in bringing forward the amendments that we debated in the last section. My apologies for forgetting that. I completely agree that EU data adequacy is vital. I completely disagree with the clause. Because I think it's technically deficient, for one of the reasons being the timeline that it lays out of 3 months, by which time I hope that we might be able to have progressed. And secondly, I think it also undermines the independence of the process that the European Commission has to go through. The European Commission has already confirmed that its review of its 2 adequacy decisions for the UK are currently underway ahead of the deadline, which is good. And as Lord Valance stated in the House of Lords, the Department for Science, Innovation and Technology and the Home Office have dedicated teams supporting the European Commission's technical review as required. I acknowledge the unilateral nature of the adequacy assessment made by the European Commission, and for this reason it is important to provide the European Commission with the discretion needed to complete their process, which I'm afraid this clause would undermine. So for that reason I'm resisting the blandishments of the Liberal Democrats.
Victoria Collins, you wish to press the...
I'm happy to withdraw.
Thank you very much indeed. Right, we now come to new Clause 3, which has already been debated with Clause 121. Sorry, withdrawn. We now come to Clause 4, which has already been debated with Clause 80. Not moved. We now come to new Clause 5, which has already been debated with Clause 70. Not moved. We now come to Clause 6, with which it will be convenient to consider new Clauses 25 and 28. Call Victoria Collins.
Thank you, Mr Turner. This is my last intervention. I'm sure you'll all be very sad on that about data. And I know that we've talked a lot about public trust, but I also want to highlight that for us as Liberal Democrats, we also are excited about unlocking the opportunities from data, and these clauses speak to that. New clauses 6, 25 and 28 together ensure we harness the benefits of data while upholding those fundamental rights. Too often data is seen as something that happens to people, rather something they have a say in. We have an opportunity here to unlock even more opportunities, not just in government data systems, but in how data is used across research, public services and wider society. New Clause 6 calls on the government to develop a clear strategy for public interest data trust and community data governance. This means allowing individuals and communities to contribute their data for socially beneficial purposes while retaining meaningful control. Imagine if patients suffering from rare diseases could securely share their data for medical research, knowing it would be used solely for public good, not commercial gain. That is a future we can build. New Clause 25 ensures that the government takes a proactive role in shaping public interest data governance, setting clear ethical guidelines for how data can be shared securely and fairly. This is about moving beyond reactive regulation. Instead, we should actively create frameworks that allow innovation to flourish while protecting those rights. If we want the UK to be a leader in responsible AI and data stewardship, we need clear structures that allow businesses, researchers and civil society to work together with confidence. New Clause 28 establishes a framework for data altruism, ensuring that those who wish to donate their data for public interest projects can do so safely and transparently. Consider a family in my constituency of Harpenden and Berkhamsted who want to contribute data to a dementia research project. Right now, there is no clear framework guaranteeing that their data will be protected from misuse. By formalising ethical data sharing models, we can enable research and innovation without compromising trust. These amendments share a simple principle. Data must serve people, not the other way round. We must strike the right balance, harnessing data to drive innovation while ensuring that public confidence and ethical standards remain at the core. And we do have a huge economic opportunity here. The UK has led the way in setting high regulatory and governance standards in areas like fintech, legal and insurance sectors where trust, transparency and compliance are critical. So we should build on those strengths, applying the same principles to emerging fields like AI, health tech and responsible data sharing. By learning from what works and setting clear guidelines now, we can unlock investment, support startups and ensure the UK has become a hub for innovative data-driven businesses. That's why I urge colleagues to consider amendments such as New Clause 6, 25 and 28 and the principles put forward to them to ensure that we build a data-driven future that is transparent, accountable and a gold standard for responsible innovation and public involvement. Thank you.
New Clause 6, public interest data trusts and communities.
The question is that New Clause 6 be read a second time, Dr. Ben Spencer.
Thank you. I listened carefully to the comments that the Lib Dem spokesman made. I just want to reflect back on one of them, which is she presented, or at least seemed to present, to my understanding, a tension between public interest versus commercial use of data. I think it's really important that we recognise and defend that a lot of health research, particularly when it comes to pharmaceutical development, is for commercial purposes, and we have a huge amount of benefits for health as a consequence. I don't think it's right to see or to try and sabotage the use of data for commercial purposes, because these have huge benefits in terms of care and treatment for people. We depend on pharmaceutical companies to spend the risk money which a state organisation never would have the appetite for to develop the new drugs of the future. And so I think it's important just to think quite carefully when one is thinking about commercial interest versus non-commercial interest for scientific research.
Mr Turner, the Honourable Member says that this is her last contribution to the debate, so in the words of Little Mermaid, I suppose we are poor, unfortunate souls. Firstly, thank you to her for her amendments. She raises issues that were raised in the other place as well. Amendment New Clause 6, as my right honourable friend, the Noble Baroness Lady Jones, noted in the House of Lords, the government is supportive of giving individuals greater agency over their data and of a robust regime of data subject rights. We have already announced our intention to publish a call for evidence on the potential role of data intermediaries. It is important that we establish a firm evidence base before we make any changes to people's data rights, so I hope that that makes her amendment unnecessary. On Amendment New Clause 25, we've already announced also our intention to publish a call for evidence on the potential role, as I've just said, of data intermediaries. It's important which is why we need to proceed carefully before we go down the route of her New Clause 25. And finally, turning to Amendment New Clause 28, the government acknowledges that there are various models of data intermediaries, including those that manage voluntarily contributed personal data for the common good, such as data cooperatives and trusted research environments. We've already announced, as I said, our call for evidence. which will seek views on various aspects relevant to data intermediaries, including the delegation of data subject rights to third parties, barriers preventing data intermediaries from operating at full capacity, and risk factors associated with significant growth in their activities. This will also include views on different models of data intermediaries, including those focused on data altruism, as she referred to. Given that we've already announced our intention to act in these areas, I very much hope that the Honourable Lady will be content to withdraw her amendments.
Happy to withdraw.
Thank you very much indeed. Can I assume that new clause 7 is withdrawn and new clause 8 is withdrawn?
Happy to withdraw 7 and 8.
Thank you. We now come to new clause 9, which has already been debated, with clause 27. Stefan Quorn.
Formally. Wish to propose it for.
You want to push to a vote?
Push to a vote, please.
The question is that new clause 9 be read a second time. As many as are of that opinion say aye.
Aye.
Of the contrary, no.
No.
Division.
Callum Anderson.
No.
Steph Ackroyd.
Aye.
Danny Beers. Chris Bryant.
No.
Victoria Collins.
Aye.
Kate Dearden.
No.
Peter Fortune.
Abstain.
Warren Durgis.
No.
Sonia Kumar. Alex McIntyre.
No.
Ben Objective.
Abstain.
John Pearce.
No.
Joe Robertson.
Abstain.
Gurinder Singh Yosan.
No.
And Dr. Ben Spencer.
Abstain.
The ayes were 2, the noes were 9, so the noes have it. We now come to new clause 10, which has already been debated with clause 117. Deborah Quorn.
Happy to withdraw.
Withdraw. Thank you. We now come to new clause 11, which has already been debated with new clause with clause 117. Withdraw. We now come to new clause 15, which has already been debated with clause 1. Victoria Collins.
Happy to withdraw.
Thank you. We now come to new clause 16, which has already been debated with clause 117. Steph.
Withdraw.
Withdraw. We now come to new clause 17, which has already been debated with clause 95.
I beg to move.
To Ben Spencer.
I beg to move.
Yeah. The question is that new clause 17 be read a second time. As many as that opinion say aye.
Aye.
To the contrary, no.
No.
Division.
Callum Anderson.
No.
Steph Ackroyd.
No vote.
Danny Beals. Chris Bryant.
No.
Victoria Collins.
No vote.
Kate Dearden.
No.
Peter Fortune.
Aye.
Warren Durgis.
No.
Sonia Kumar. Alex McIntyre.
No.
Ben Objective.
Aye.
John Pearce.
No.
Joe Robertson.
Aye.
Gurinder Singh Yosan.
No.
And Dr. Ben Spencer.
Aye.
The ayes were 4, the noes were 9, so the noes have it. We now come to new clause 18, which has already been debated with clause 95. Dr. Ben Spencer to move formally.
I beg to move.
The question is that new clause 18 be read a second time. As many as are of that opinion say aye.
Aye.
Of the contrary, no.
No.
Division.
Callum Anderson.
No.
Steph Ackroyd.
No vote.
Danny Beals.
No.
Chris Bryant.
No.
Victoria
No
Collins.
vote.
Kate Dearden.
No.
Peter Fortune.
Aye.
Warren Durgis.
No.
Sonia Kumar. Alex McIntyre. Ben Objective.
Aye.
John Pearce.
No.
Joe Robertson.
Aye.
Gurinder Singh Yosan.
No.
And Dr. Ben Spencer.
Aye.
The ayes were 4, the noes were 9, so the noes have it. We now come to new clause 19, which has already been debated with clause 95. Dr. Spencer to move formally.
I beg to move.
The question is that new clause 19 be read a second time. As many as are of that opinion say aye.
Aye.
Of the contrary, no.
No.
Division.
Callum Anderson.
No.
Steph Ackroyd.
No vote.
Danny Beals. Chris Bryant.
No.
Victoria Collins.
No vote.
Kate Dearden.
No.
Peter Fortune.
Aye.
Verinder Just? No. Sonia Kumar? Alex McIntyre? No. Ben Obsojective?
Aye.
John Pearce?
No.
Joe Robertson?
Aye.
Gurinder Singh Yosan?
No.
And Dr. Ben Spencer.
Aye.
The ayes were 4, the noes were 9, so the noes have it. We now come to new clause 20, which has already been debated with clause 95. Ben Spencer to move formally.
I beg to move.
The question is that the new clause 20 be read a second time. As many as are of that opinion say aye.
Aye.
And of the contrary, no. Division.
Callum Anderson? Steph Acheron?
No vote.
Danny Beals? Chris Bryant?
No.
Victoria Collins?
No vote.
Kate Dearden?
No.
Peter Fortune?
Aye.
Verinder Just?
No.
Sonia Kumar? Alex McIntyre? Ben Obsojective?
Aye.
John Pearce?
No.
Joe Robertson?
Aye.
Gurinder Singh Yosan?
No.
And Dr. Ben Spencer.
Aye.
The ayes were 4, the noes were 9, so the noes have it. We now come to new clause 21, which has already been debated with clause 81. Victoria Collins to move formally or withdraw? Move formally. The question is that new clause 21 be read a second time. As many as are of that opinion say aye.
Aye.
And of the contrary, no. Division.
Callum Anderson? Steph Acheron?
Aye.
Danny Beals? Chris Bryant?
No.
Victoria Collins?
Aye.
Kate Dearden?
No.
Peter Fortune?
Abstain.
Verinder Just? Sonia Kumar? Alex McIntyre?
No.
Ben Obsojective?
Abstain.
John Pearce?
No.
Joe Robertson?
Abstain.
And Gurinder Singh Yosan?
No.
And Dr. Ben Spencer.
Abstain.
The ayes were 2 and the noes were 9, so the noes have it. We now come to new clause 22, which has already been debated with clause 70. Victoria Collins to move formally.
Withdraw.
Withdraw. We now come to new clause 23, which has already been debated with clause 80. Victoria Collins to move formally.
I'm happy to withdraw.
Thank you. Withdrawn. I now come to new clause 24, which has already been debated with clause 80. Victoria Collins to move formally.
Withdraw.
Thank you very much. Withdrawn. We now come to new clause 25, which has already been debated with new clause 6. Victoria Collins to move formally.
Withdraw.
Very grateful. Withdrawn. We now come to new clause 26, which has already been debated with clause 80. Victoria Collins to move formally.
Withdraw.
Thank you. Withdrawn. We now come to new clause 27, which has already been debated with clause 92. Victoria Collins to move formally.
Withdraw.
Thank you. Withdrawn. We now come to new clause 28, which has already been debated with new clause 6. Victoria Collins to move formally.
Withdraw.
Thank you. Withdrawn. We now come to new clause 29, which has already been debated with clause 124. Victoria Collins to move formally.
Withdraw.
Thank you. Withdrawn. We now come to Government Amendment 48, to the title of the bill, which was debated with the Government Amendment 28. The question is that the amendment be made. As many as are of that opinion say aye.
Aye.
And of the contrary, no. I think the ayes have it. The ayes have it. We now come to the final question in these proceedings, that I do report the bill to the House. The question is, sorry, Victoria Collins.
Visitor, I lied when I said my last intervention. I realise how much... I just want to say a great thank you to the clerks and to yourself as chair and other chairs who have been on this committee, and also to the government and us for working together to get through this bill very quickly. So I just want to say thank you for that.
The question is that I do report the bill as amended to the House. As many as are of that opinion say aye.
Aye.
To the contrary, no. The ayes have it. The ayes have it. The committee has finished its work. Order, order.
Committee Room 11, sound. Committee Room 11, sound.